that has come in today or that has logged in today. I'm really not going to reintroduce myself. The introduction was pretty precise and spot on. And I just want us to get into what we are discussing today, intellectual property made simple. Ideally, I know many of us have not heard or are hearing the word intellectual property in bits and pieces, and I've never gotten time to really appreciate and understand this very core business component. And one of the core things that we always talk about is a few times when you sit down and think of something, you've come up with an idea. And many times we tend to hear people talk about, or I came up with idea X and I own the idea. Okay, so we want to get that cleaned off and be straightforward and say you can never own an idea. When it comes to the world of intellectual property, you only own what you've conceptualized out of the idea. Okay, so the idea is like wind. If I sat down today and said, I need to design a model or an AI model that could detect disease in poultry, that is just an idea. Where is the actual model? So the IP will be in regard to the actual model you've designed, not the idea that you thought about. That is very, very important when it comes to the world of intellectual property. So what is intellectual property in general? Basically, intellectual property is more like once you sit down and create something, okay, like I've mentioned earlier, once you sit down, create something, design something, create a service, create a product, whatever it is you've come up with, that is what we refer to as intellectual property, all right? And when you go through the different forms of intellectual property that I'll be talking about later, and you settle down with just one that really aligns with the service or product you've created or designed, you're then granted what we call intellectual property rights. And I really would love to emphasize that when we go in for intellectual property, for as long as you've created something, okay, if you've created this, I'm going to use this AI model for detection of maybe coccidiosis in poultry. I've seen someone into poultry farming among part of the participants. I want to use that as an example. If you design an AI model to detect disease, coccidiosis in poultry, and then you go out to seek intellectual property protection, it is not a guarantee that you will actually be granted these IP rights. There are terms and conditions that have to be followed, and there are also SOPs that you have to follow. The different steps have to be satisfactorily and without any doubt. These all have to be met. So it is a journey that you have to walk, yes, and it is a journey that is quite very interesting at the end of the day. So one of the core characteristics of intellectual property, it is intangible in nature. That is what I said. It is intangible in nature. However, when we get to the point of conceptualizing the idea, that is when we get to see something substantial be created. In the product development cycle, for those of us that are conversant with it, we do have different stages of product development. And the first stage of product development is ideation. You're deliberating, you're discussing either with your team, either with your partners, with your classmates, with your business partners, etc. That is, you're generating ideas. And as you generate these ideas, you then get to break them down to what is actually relevant and what can actually be taken on, or that can be pushed into something that we may call a prototype. Okay, now when you get to that point of prototyping, that is super, super important. A prototype, for those that may not know this word, it is just a mimic of what the final product would look like. Yes, when we get to this point of prototyping, at that point, we should have known what IPs we are going for. And if possible, we should have already applied for different forms of IPs that coincide with what we have developed and designed. So right from the time when you're generating ideas, right from the time when you're discussing as a team, you then have to think in the IP direction. If it is a trademark, for you to identify your product in a very unique manner, please take the steps and secure that. If it is a patent, for as long as it's a technical innovation, please go ahead and push for that. And in case it is for those that are into the arts industry, if you need to go the copyright route, please go ahead and exploit that. The earlier, the better. I will really emphasize this in the coming slides, slightly ahead. And then the second characteristic of IP, as the IP owner, when, for example, you go to the local IP office here in Uganda, which is URSB, when you go to URSB and you're granted IP rights, you have exclusive rights. You enjoy the exclusivity, okay? However, there are terms and conditions that you have to fulfill. For example, yes, we shall talk about the different forms of IP later. For example, when we get a trademark, when you design a logo, yeah, you have up to 10 years, but you continuously have to pay your renew fees. That is, those are what we call the terms and conditions, and you enjoy exclusivity. That is why when we get to the IP world, for those that have finally secured their intellectual property rights, you really have to be very strict with ensuring that nobody uses your technology without your authorization. Why? Because you have the exclusivity, you have the authority for the period of time allocated to that particular IP. Nobody is supposed to use your IP without your permission. And then, like I've mentioned, still IP protection has a time limit. For example, if we talk about a patent, you have exclusivity over your patent for 20 years. If it is a utility model, you will run for 10 years. If it is a trademark, every 10 years you have to renew, etc., etc. And then another characteristic of intellectual property, IP is territorial. What do we mean by being territorial? For example, I'm in Uganda today, and maybe Ronald sat down and designed something, and he feels it won't only be exploited in Uganda alone, but it can actually do well in the East African region. I'm giving an example. So you sitting down here in Uganda and seeking intellectual property protection at URSB or with URSB will not be enough, because your IP rights will only be valid here in Uganda, because that is where you sought intellectual property protection. Okay, so in case you want to get IP protection for your innovation across the region or different countries of interest, you have to visit those particular countries' IP offices. But keep in mind, every country has its own intellectual property law, and you have to go by what the country's laws say, what the country laws say. That is something that is not subject to discussion. However, I would also love to inform you that you may not even need to go to all these countries individually, because we do have a regional intellectual property office. We have a regional intellectual property office, and then we also have the World Intellectual Property Office. I'll talk about these different routes. So when we talk about intellectual property, okay, we have 3 routes. One, it is the local IP route, where we go to the local intellectual property office. For example, here in Uganda, we go to ARIPO. We go to URSB, that is Uganda Registration Services Bureau. And then the second route is the regional route, where we go to ARIPO. ARIPO in full is the African Regional Intellectual Property Organization. And this organization, so far, we have 28 countries, African countries, that subscribe to this particular regional IP office. The head offices are in Harare, and that is Zimbabwe, and still they've let all their services be electronic. So you can go in and put in your application online, and you simply get your IP for as long as it meets the requirements. And then the third route is the World Intellectual Property Organization or Office. For those that can, you can just simply Google WIPO, WIPO, and create an account. And before you know it, you're actually having access to whatever service they offer. That also includes, the WIPO actually also does offer online free courses for those that may want to learn more about intellectual property. And then, given the fact that intellectual property is territorial, we also need to be smart with ensuring we submit timely, strategic, and detailed intellectual property applications. I would love to give an example. If me, Antonia, and maybe Edson sat down and created a particular innovation, okay? And by so doing, maybe Antonia is smart enough and rushes to URSB and claims to have the ownership of this particular innovation, okay? Ideally, it is a 3 man's work that one person is actually claiming to own. And as URSB, they will not go in to find out who did what. You just simply fill in a form and detail who the inventors are. For as long as Antonia has not stipulated and said Fiona and Edison were part of the team, it was a team of 3, and she insists that it was a team of 1, that is what URSB will take on. So we need to be smart with the people we create innovations with. And then also we need to be very technical when it comes to the timely submissions for our applications. I'll still re-echo this in some of the slides. I think it will be slide 17. So we do have a number of categories of intellectual property. I know you've had some of these. You've heard about some of these. Copyrights, we do have the industrial property, and under industrial property, we do have patents, we do have utility models, industrial designs, trademarks, trade secrets, geographical indications, and then we have the plant breeders' rights, and then the traditional knowledge. I'm going to break this down one by one. Let's start with copyrights. So when you get to copyrights, these are rights that are granted to just the literary and artistic works. We've had a lot of noise with the musicians and the arts industry, the Uganda copyright law, it needs to be effected, etc., etc. This is what they are really pushing for. They need to feel that they are getting something out of what they've really invested in. So copyrights is valid for music compositions, is valid for paintings, films, novels, etc., for as long as it is in that line of artistic works, okay? And when it comes to copyrights, protection is for a lifetime, okay? Supposedly, I created a song, yeah, and I went through the proper channels, got copyright protection. Until the day I die, okay, I will have exclusive ownership of this particular IP right, and plus 50 years after my death, okay? So the offsprings or the next of kins will benefit from my works for the next 50 years. And we've seen this happen a lot, especially when Michael Jackson passed away. You saw how his estate really got to be managed even after his death. His children and the family are able to benefit from his creations and his works. And additionally, once you're granted copyright, once you're granted a copyright as an IP right, you definitely drive what we would call prevention of distortion of your works, especially when it comes to this day and age where we have a lot of immoralities around, you know, especially for those of us that are onto social media. We are always on online trying to read and see and study different things. We get to see lots of these things. However, there is a limitation. For as long as someone has really protected their works, there are terms and conditions that they will be aligned with, and you who would want to have access to this, you have to meet the requirements. If it is X-rated, then you have to be above, I think, 18. For those that below, there are those regulations that are always attached to different content that we get to have access to online. So those are copyrights. And then we move to the second form of intellectual property, which is industrial property. And the easiest way that we can explain industrial property, these are just the creation of the mind that are used in the field of industry and trade. What we are into right now, what we are talking about right now. And the first form of industrial property I really would love to talk about is patents. So patents is protection, or a patent is a protection granted to a technical solution to an existing problem. Whenever we are getting into product development, we do not create a product because we are wasting time. We identify a problem, see how best we can solve this problem, and at the end of the day, we get to develop a product, or we get to develop a service. Okay, so that is a technical solution. And now when you come through with these technical solutions, there are 3 requirements that you have to meet for you to be granted patent rights. 1, your technical solution has to be new. It shouldn't be anywhere in the public domain. And then 2, it must involve an inventive step. By inventive step, we are really being precise with the unique step that you have taken on, or the unique step that you created to come through with this particular product. And then 3, it must be industrially applicable. Okay. Some of the examples that we normally use in our day-to-day lives, for example, a safety pin. This was patented. However simple it looks, it was patented. Okay? It solved a certain problem. For those of us that buy eggs, especially in the supermarkets, we usually see the eggs packaged in a certain way. This packaging was patented, and you can clearly find this information online. You can just simply go to Google Patents and search for whatever you want to know. All this information is there, okay? And once you're granted patent protection, you have exclusivity over your IP for 20 full years. And the 20 years start from the day you submit your IP or your patent application to the respective intellectual property office. But I would also love to emphasize that within the 20 years, you still have to do your due diligence, what we would call paying your annual maintenance fees. And someone will ask me, why would I be granted a patent right and still pay annual maintenance fees of maybe 50,000 or 70,000 shillings? That is a serious question. But the reason as to why URSB lets us do this is to ensure that whatever innovation you've come through, especially this technical solution, it's not just seated on the shelf. It's actually out there doing what you designed, doing what you wanted it to do. Okay, someone designed this packaging for eggs. It should be out there doing what it's supposed to do. So now that is when you have to think how best you're going to exploit your patent. How are you going to commercialize it? Okay, because ideally it is a must for you to pay your maintenance fees, because once you do not pay these fees, you will lose your IP and it will be difficult for you to get it back. So it is super, super important that you do your due diligence in regard to maintaining your patent for as long as it has been granted. But even initially, prior to being granted, make sure your technical solution meets these 3 requirements. Now, we do have lots of excitement, especially for us innovators and entrepreneurs. When we come up with a new product or service, we like to put it out in events. We can attend an exhibition somewhere. Maybe you're invited for a workshop and you kind of put your innovation out there for people to see for different reasons. One, maybe you're looking for someone to invest. Maybe you're trying to look for someone to partner with. Maybe you're trying to get your product popularized. Yes, it is okay for you to do this, but we need to ensure that you have sought IP protection first. Because when we get into patent application, there is what we call an examination process that has to take place. Okay, when you apply for patent protection, you have to go through a substantive examination. And once you get to substantive examination, the patent examiner is really going to go in and search and validate that actually this innovation meets the 3 conditions. And then by getting to clean up and ensure that this is a new innovation, they shouldn't find anything in the public domain, be it online, be it anywhere. It should be very confidential information up to until you've gone in for patent application. We really need to take note of this. That is why I said earlier when I was beginning that the earlier, the better. Once we get to discussing ideas, prior to even conceptualizing the idea by coming up with a prototype, can we identify the appropriate IP and seek intellectual property protection? Until you get to that point of application for that particular innovation for any form of IP, you then can proceed with whatever you want to do, trying to seek funding, trying to seek a partner, trying to popularize your product, etc. That is okay. But first do the first thing, which is seek IP protection. Okay. The second form of IP as well is the utility model. Some people usually refer to a utility model as a baby patent, because we are literally having this IP given for just an incremental, that's something you've just added onto an existing technology, basically. Yeah. And one of the things that many of us have, we do have mobile phones. And many times when we buy a mobile phone, you go in and buy a jacket. Okay. You go in and buy a screen saver. These are just increment. This is something that you're just acquiring. This is something that was just designed to help protect this particular innovation. So it's just an incremental aspect. Now that is what will qualify for a utility model. Once you're given a utility model, right, this will run for 10 years, right from the filing date. But also, just like the patents, you also have to do your due diligence in paying your maintenance fees. The payment fees or the maintenance fees for patents versus utility models are quite lower. The utility model fees are quite low compared to the patent maintenance fees. However, you still have to meet the same requirements in regard to the utility model as well. Yeah. And still, when we are applying for a patent or utility model, we need to provide what we call a document that entails what our innovation is, how it's done, who does it, when it's done, etc., etc., because we need whoever is going to be examining to actually understand what we have designed and created. And I would also love to mention that after your utility model rights have been granted or patent rights have been granted, this information is put out in the public. It doesn't stay confidential anymore. It's put out in public. However, nobody has the right to use your IP without your authorization up to until the 20 years are done. Now, the 20 years may look as very many years, but in this today's world, where on a daily basis people are creating something new, you do not have to take the 20 years for granted. That is actually very little time. So on a daily basis, ensure that you make your innovation better, irrespective of you getting a patent or a utility model for your innovation. Still invest in research and development to make your innovation better, and whatever improvements you've added to ensure that you seek appropriate IP protection for it, for you to stay relevant in this very competitive world of innovativeness. Now, the other form of IP is the trademarks. I can clearly see Enterprise Uganda has its trademark here. Okay, that is a unique identifier. So basically, when we talk about a trademark, we are looking at something that already existing innovations. Yeah. When we get to creating and designing different products or services, I want us to always keep in mind that you're not the first person that has created this. Please always remember, you're not the first person that has created product X, but you will be the first person that has designed or created product X for as long as you have incorporated something unique that no other person has done to come through with that particular product. I hope that is clear. So when we get to designing unique identifiers, when we get to branding our products, a trademark is very, very important. And one of the conditions for a trademark to meet, one of the conditions that the trademark that has been designed has to meet is, one, it must be distinctive and not deceptive. It must be unique. Very, very unique. And a trademark can be a logo, it can be a sound, it can be a label, it can be a slogan, it can be a scent, it can be words, for as long as you know that this actually aligns with your particular product. Some of the trademarks that we have already in Uganda, for example, we have plain word trademarks. For example, Move It. For example, Reham, Bell, Jessa. These are just words, okay? And then we also have logos or trademarks that can be both a symbol or a combination of signs. And one of them is the plain logo without any words. We do have the Centenary Bank logo. We do have the Shell, Shell Petroleum Company logo. And then we do have, still part of the logos, we do have the sterilized words. Someone can mix a few images or use specific fonts or put something to signify something that they've designed. And one of the trademarks, for example, at Narrow, that we protected is Superlight. These are lighters that were designed by one of the Narrow institutes, that is Nafori. And then we have the common, some people really enjoy this drink Kazire. You can see how it was properly designed and, you know, put out there for the public to consume. And then for those that love going to Cafe Javas, still they did trademark this particular word Javas, and they used a specific font and color to really represent their product. So whatever it is you feel will appeal to your end user is super, super important for you to incorporate as you design your trademark. Please keep in mind that when you're trying to design something that distinguishes and identify your product from the already existing products, you're not designing it for you. You're designing it for them. You know, we consumers have a lot of complexities when it comes to being judgmental about different products we consume. I may buy a product not because it is good, but because the labeling is super nice. I may buy a product because it is expensive, yes, but I like how the shape of the logo looks like. Okay, or I may buy the product because it has a very beautiful shape of maybe it could be a perfume, it could be a cream, name it. That's how we consumers are. So you, as an entrepreneur, it is important that you put this at the back of your mind. Yes, there is that sentimental attachment when you've put in the time, when you've put in the resources to design these different products. It is okay for you to have that attachment, but ideally, you're not going to use that product. You're producing it for them. You're designing it for them, not you. Okay? You're designing it for them. So you need to put yourself in the minds of your consumers and think, if I design X as my trademark, will people really get to understand what I'm talking about? Will they like it? Will it contribute to having my product really spread out? Will it help distinguish my service or good from the already existing providers? etc. Those are questions that you, the product development teams, the business owners and entrepreneurs have to answer. You have to think for the end user or the consumer. Now, another form of trademark, we do have shapes. I know many of us have seen Coca-Cola. The shape of the Coca-Cola bottle was registered as a trademark. Okay, that is one of the examples. And then we do have signatures. For those of us that love movies, Disney as a signature was trademarked. We do have the musician Taylor Swift. She trademarked her signature just to make sure they stand out. You choose what will work for you, okay? And be sure to be consistent with using that very particular registered trademark. Do not change it. If you want to change it, please follow the right procedure in regard to the IP office in which you sought IP protection for that particular trademark designed. All right? So when it comes to the trademark, for as long as you do your due diligence in paying your renewal fees, IP protection is definite. For the rest of the lifetime for the particular product you've designed, just make sure you do your due diligence in regards to paying the required renewal fees. As simple as that. Okay? The other form of IP that is very, very interesting
is it just me or is still breaking? Can everyone hear her clearly? Eric, can you hear me? Okay.
sit
No,
down and try and
Theo, we lost you for a couple of minutes, maybe half a minute. Looks like the connectivity is breaking. You could kill the video and see if it can get better. Okay.
we are talking about confidential business information. That secret recipe, that secret technique that you incorporated in designing your trademark. For those that are into IT, the source code is a trade secret that you need to protect seriously, because once someone gets access to that source code, they are able to redesign whatever it is you've taken time to create. Okay, so but we do not have, like I was mentioning earlier before I broke off, we do not have any definite route for IP protection when it comes to trade secrets. However, a trade secret is only considered a trade secret for as long as it is kept a secret. And there are ways you can maintain this secret. One, make sure any person that has access to this information signs what we call a non-disclosure agreement or a confidentiality agreement. That is super, super important. You need to ensure that any person that gets close to this information does their due diligence in this regard. Make sure an NDA is signed, make sure a confidentiality agreement is signed, make sure the storage places in which you have these files, these recordings, still is super, super secure. Not every person should have access to this confidential information. Are you aware that a number of people have really tried to replicate how Coca-Cola tastes, but they've never been successful? Actually, Coca-Cola recipe is one of the best kept trade secrets in the world at the moment, because they have really done their part in ensuring that nobody has access to this recipe. How they've done it, I am not able to tell, but they've managed to successfully have this executed. So for us business owners, for us entrepreneurs, we do have that very important and solid information that we hold on to. Okay, make sure nobody has access to that information. And still, if there is need for someone to have access to it, do your due diligence in ensuring that you've taken the necessary steps to ensure that this information is not leaked to any person. Okay, this is super, super important. And yes, trade secret theft is very, very, it's quite very common, even amongst the big companies. Yeah, it's quite very, very common. And many times we tend to downplay the fact that someone has leaked information X to company Y, but still, if you really do a thorough check, you may find company X did not take the necessary steps in ensuring that information is not leaked anywhere. And even when we get staff hired as entrepreneurs for us that run businesses, you may not necessarily be there to run the business day in, day out for those that have different jobs or different enterprises. But even then, those few people that have had access to this information, it is okay for them to do their due diligence, and it's okay for you to implement the fact that they signed those non-disclosure agreements. And the penalties for disclosure of the secret should really be hefty, that they never ever dare to leak any information about your business, about your recipe, about your technique, etc. They should be intimidated, and they should never be in position to have this power to give out this information. So it is up to you business owners to be very strategic and smart. Be strategic in regards to ensuring only people that matter have access to this very important information. Okay, now that is about trade secrets. And then we do have what we call the industrial designs, the physical or the ornamental appearance of a product. Still, I'm going to use the Coca-Cola bottle. This was awarded industrial design protection. However, the difference between industrial design is that you only have exclusivity of this industrial design for just 15 years, and you have to renew every after 5 years. Okay, that is the difference with industrial design. And for those that would want to brand, for those that would love to design their product to look a certain way, it is important for you to think about a very unique industrial design. It could be a shape, could be a color, could be a pattern, etc. And also have this shape or color integrated with your trademark, your unique trademark, and then properly present a very beautiful and presentable design for your product. I would love to give an example of, I know many of us, I think sometime last year, we did hear a lot of noise about the UCU graduation gowns, and people were saying they look like church gowns, they look like, oh God, the downplaying was really solid from the different pupils that saw the designs on social media. But I would love to tell you that actually all these designs did pass industrial design protection. And for those of us that have access to the UPPC portal, you can visit the Uganda Gazette and see that actually these designs were gazetted, and very soon you will be getting the certificates for their very unique designs. So now the design of the graduation gown is part of the branding of UCU as a university as a whole. So you need to be smart, you need to be creative in designing something that actually will help elevate your business, and then two, will be a stepping stone for you as a business owner, especially when it gets to creating partnerships, when it gets to seeking funding from different people of interest or companies of interest. That is all up to you in regard to being as creative as possible. Then the other form of intellectual property, these are geographical indications. Basically, geographical indication rights are granted to products with unique features that are attributed to their geographical origin. And just like this, you can read on the slides, this basically mainly applies to agricultural products, to foodstuffs, to wines, etc. And these particular features of these different products in regard to the geographical origin is mainly attributed to by the different soils, the climate, the altitude, and even the culture. You know, how people do what they do in these different areas does contribute to the uniqueness of this particular product. Yes. And then also still, when it comes to geographical indication, the period of protection is indefinite. You still have to do your due diligence in regards to renewing your IP rights or your geographical indication rights. Yeah. Commonly, I know many of us usually go to the markets and we would love to buy Irish potato, and we are quite specific. We tell the traders, I only want Irish potato from Kabale. Why? Because we have reasons. We have reasons as to why we love this Irish potato from Kabale. Maybe it's because of the texture. Maybe it's because of the color. But that doesn't come from nowhere. Okay, that doesn't come from nowhere. It is attributed to the different soils, climate, altitudes with relation to Kabale, where we get this particular Irish potato. I know you've had arguments where someone will tell you the Irish potato from Kabale, okay, does well when it comes to just boiling and eating the Irish or frying the Irish. And then the Irish from the eastern part of Uganda is very good when it comes to making fries. I think you've heard about that, that comment. And there is reason for this, yeah? It is geographically related. I would also love to talk about the plant breeders' rights. Basically, this is all for all those of us that are into plant breeding, creating new plant varieties. There are conditions that you have to meet in regard to this. And one of them, when you come up with a plant variety X, okay, that variety to be granted a plant breeder's right, it has to be new, of course, it has to be distinct, and it has to be uniform and stable. If you say that if I've taken time and have taken time to breed this variety of X for maize, this particular maize, in whatever you're writing, you may say, when you plant maybe, when you plant maize, each plant will give you, I'm just giving an example, you'll have a maximum of maybe 3 cobs. Okay, that is your argument. But you have to properly stipulate the conditions under which this particular variety X will be able to give us the 3 crops. Now, once you stipulate this and someone else goes and plants this very plant variety in another area and they do not get what you actually talked about, then we'll have to query the stability and the uniformity of this particular variety. So you need to be very specific. You need to take time. And by the way, plant breeding is not a 1 year, 2 years thing. It really takes time for you to come through with these very unique plant varieties. It really takes a lot of time. Yeah. And of course, once you're granted plant breeders' rights, yeah, the period for crops is 20 years, and then 25 years for trees and vines. That is what we follow as well in regard to the IP law or the IP guidelines. Then also the other form of IP that we often take for granted, especially with the land communities, with the people that feel we know more, we tend to take advantages of people, especially in the indigenous communities. I did interact with a team, a product development team one time, and they were talking about a certain, I'm really not going to give details, but there is a community somewhere within the central region that uses a certain sap, a sap collected from a particular tree to kill ticks. And this particular scientist was claiming that this is my innovation. But on further checking and interaction with these indigenous people, they have been practicing and using this for over 20, 30 plus years. It's been part of them. So now, what would you really call this? Isn't this taking advantage of people or communities because they do not have the actual information, the technical information that you're talking about? They've been doing this for years. They've been practicing this for years. And to them, it is indigenous knowledge. It is traditional knowledge. Yes, it's a form of IP, but they do not know. They do not know how to actually get this. So now for us as entrepreneurs, as innovators, when we identify these people, we need to be quite very specific. Inform them about what you're doing and how you're going to do what you're doing and how they are going to benefit. Because ideally, you're not going to invest time and money in exploiting an existing traditional knowledge and expect not to want to get returns. The communities also have to get returns. So it is important that you seek consent, okay, after thoroughly educating and talking to these different people. And the commonest forms of indigenous knowledge we do have in Uganda as of now is the designing or the preparation of the bark cloth. I've visited communities that do take time to prepare this backcloth, and I must tell you, it involves a lot of skill, a lot of time, a lot of patience, and you cannot take that away from them. Okay, we do have lots of traditional medicines that are prepared in our communities. Would you want to go out there and claim that this is yours? No, this has already been in practice for very many years. And people have actually been using these different things, the traditional medicines. The backcloth has been prepared for a good number of years as well. So we need to give respect to the indigenous communities as entrepreneurs, but also if we want to elevate and exploit the existing knowledge, we need to follow the right steps and do our due diligence in regards to educating and informing these communities, one, and then two, we need to support and see how best we can add value, especially in regard to the economic value to these particular products and services. We shouldn't take this for granted at all. I did mention earlier that we do have IP protection routes. Yeah, one of the routes, that is the national route, or the local route, that is through the Uganda Registration Services Bureau. So when we say that intellectual property is territorial, when you go to URSB and seek IP protection at URSB, your IP is valid within the territory of Uganda. You can never go to Kenya and say, oh yes, I claim this IP because I sought protection. They will ask you, did you seek protection for this IP in Kenya? If it is no, then it is no, you cannot claim that IP. Okay, so as product development teams, as entrepreneurs, as inventors, it is important that we keep this at the back of our mind. Yeah, if you're designing a product or service, try and assess where your product will actually be heavily exploited, or where you think your product or service will be relevant, and seek IP protection in regard to that particular decision that you've taken. The second route I did mention is through the regional route, that is the African Regional Intellectual Property Organization. And I told you we do have 28 countries that subscribe to this, 28 African countries that subscribe to this IP office, the regional IP office. And it is important that you do your due diligence. It is very good that everything has been put out online, so you can seek IP protection from URSB in the comfort of your office or home or your business. You can still seek regional IP protection in the comfort of your home or office or business. Even if you want to follow the international route, where we do have close to 160 countries, it is okay for you to do it online because the services are online. You just need to ensure that you do your due diligence in regard to the payments, because ideally, for you to seek for any IP protection, each IP has specific fees that have to be paid. And then you also have to follow the laws, or you have to follow the procedure in regard to the different IP route you've decided to take. Now, for the national route, for example, URSB. With URSB, when we talk about maybe a patent and utility model, you have to fill in application. You have to fill an application form. You have to pay application fees. Then you have to submit a number of documents, and one of them is the patent document. When we talk about patent, that document has is comprised of all the details about what this innovation is about, how you did it, where you did, how you did it, and how does this innovation actually work. And then still within this this document, you properly have to stipulate what the unique aspect of your innovation is. If it is a technical step that you took, you have to strategically and in detail explain this particular step that you did implement in order to come through with this particular innovation. And then once you have this complete patent document, you then go ahead and submit your application to the USB email. Now, when that is done, an examination of your patent will then commence. And then the first form of examination that will be done is a formality examination, where the examiner will check if your application, if you've submitted all the necessary information in regards to your patent application. Have you paid your fees? Have you submitted your patent document? Does your patent include what we call claims, the innovative aspects of your innovation? That is what we would call the claims, what you actually claim you did invent or you did create. Are the inventors properly stipulated in the application? I think I've talked about the fees. Have you submitted your application letter? Now, once all these have been found and the examiner is satisfied with your submission, you're then required to pay a certain amount of money for you to then, for your application to then proceed for what we call substantive examination. Now, the substantive examination, that is where we shall have the patent examiner thoroughly examine your innovation, okay? And there isn't any definite period for when this substantive examination will take place. It could even take a year when an examiner is thoroughly looking at your innovation. Now, once they feel that you meet the 3 requirements we did talk about earlier, and by the requirements we are referring to, it is novel, it is industrially applicable, and then it involves an inventive step, you're then given a go-ahead, okay, to gazette your publication, and then you'll also be required to pay your registration fees, and before you know it, you already have your certificate of registration for your innovation or for your patent. That is the procedure. Now for patents and utility models. Still for trademarks, it's all the same thing. The only difference is the fees vary from different IPs, okay? If you want to go the national route through URSB, for you to apply for a trademark, you need to pay about 25,000 for a trademark search and then 50,000 for application. For a patent, you need to pay 100,000 for application. For industrial design, still the same amount. So you need to do your due diligence in regard to ensuring you have the appropriate information regarding the actual fees to be paid for you to go in and submit your application for the form of IP of interest. Now, as entrepreneurs, why do you think IP matters to entrepreneurs? Why is it important that entrepreneurs really take IP matters as serious as they should? One, with IP assets, for example, patents, with a trademark, you're able to increase your business value. Okay, for example, when you get to a point of licensing or creating partnerships, or you no longer have the time to run your business and you feel you just need to sell off your IP. IP will be a very big stepping stone for you as an entrepreneur, because you will have elevated the value of your business. And then 2, it is very easy for you to attract investors, or for you to attract potential partners, okay? Or it's easy for you to establish very strategic and important partnerships. Why? Because any person that will be coming in to create something with you, they will definitely know in regard to what you've presented to them in relation to IP, they will clearly have a good percentage of trust in your business, okay, as a whole. And then, of course, with the proper branding, especially with the unique industrial design, with the unique trademark, you're able to market and create a very strong presence in the market that is super, super competitive. And remember, still, even after seeking IP protection and maybe you've been granted, it is important for you to stay consistent, because irrespective of you having very strong branding strategies and marketing strategies, good trademarks, good industrial designs, customer loyalty is super, super important. You have to maintain the quality and quantity of your product. One, you have to properly brand your product. You have to properly popularize your product, because it's quite competitive in the market. We all know that as entrepreneurs. And then since once you get IP rights, you have exclusivity for a certain period of time, you're able to prevent yourself, or you're able to protect yourself from any imitation or unfair competition. We know people that like to imitate. We know people that like to replicate different products just because they are doing well in the market. Yeah, so it is important that with this IP at hand, you have an upper hand. You're able to secure your market advantage. And in regard to this still, I would love to tell all of us that irrespective of you securing an IP, you please also have to invest in enforcement of your IP. Okay? You need to invest in enforcement of your IP. You don't just sit back and say, oh, no, you just had my trademark. No one will. I mean, it's mine. I already have a certificate for it. But what if someone else out there in the market is actually exploiting your IP without your authorization? How will you know if you have not taken the necessary steps to ensure that you enforce your right? It is your responsibility for you. It's a responsibility for you to keep enforcing your rights within the market, because you need to secure your position in this very competitive business environment. And then, what are the IP strategies that I suggest you should adopt? One, conduct an IP audit. For those of us that have developed different products or services, let's take a step back after this meeting. Try and assess what exactly it is that you've designed. Okay, what are these different services that you've created? What are these different products that you've created? How can I make these products more strong? Do I need now to design a trademark? If yes, go ahead and do it. Do I need to design or do I need to go ahead and put this product up for patent protection? If it meets all the requirements, please go ahead, okay? Do I need to find ways of designing the packaging of my product, an industrial design, a unique one, and subject it for protection for as long as you feel it is relevant? And I know it is relevant, please go ahead and do your due diligence, because we do not want you to miss out on any strong IP assets that you've come up with. And then, please, you need to prioritize. Yes, you're identifying all these products that you've created, all the services that you've created. Try and assess the priorities that you have. That is, what should you protect first? If it is a technical innovation, maybe you've come through with, for example, that model that detects coccidiosis in poultry. Okay, is it important for you to first go in and submit this for patent protection, or you first design a trademark? That is a decision for you to make, but ideally, you need to first go in and seek for patent protection or utility model protection, and then follow up with a trademark later. Yeah, and then, like I did mention earlier when I was starting this presentation, please ensure to register early enough. I know we have opportunities as entrepreneurs. You want to go to events and display your innovation. You want to go to workshops. You want to popularize your product or service as much as possible. But please keep in mind that before any public disclosure, first seek your IP rights. For those of us that are into academia and are doing a lot of research, we have publications coming through. Please ensure that before that publication comes through, you've sought IP protection first, because it hurts. And I usually tell people that it's not that we Ugandans are not innovative. No, we do have a lot of people creating different things. Students in universities are always designing, people are writing research papers on a daily basis. Undergraduate, postgraduate, PhDs, people are always doing research. Okay, that means people are being creative. Students are being creative, but where do all these things go? How come China tops the list of tops the list of a country holding the highest number of IPs? It is not that they are doing a lot of work, but they come and see a gap where someone has created something and they're not doing their due diligence in regard to protecting it, and they will go and protect it and own it. And yet, ideally, it is you that came up with this particular idea. So we need to do our due diligence in regard to protecting our IPs. And then, like I did mention earlier, it is important as an IP rights holder or owner, please ensure that you monitor and enforce your rights. Okay, keep an eye on your competitors. Okay, I know of a company that once in a while will go into the market and buy products, different products from different companies, irrespective of them producing or designing the same products. But they will try and assess, what is this person doing? Are they mimicking what I already protected? Are they mimicking my trademark? Etc. etc. You need to put your foot on the ground in regard to your innovation. And then, as innovators still, as entrepreneurs, we do have a number of mistakes we make. And I need all of us to stop making these mistakes immediately after today. That is my humble request. One, let's not delay registration of our IPs. For as long as you have sat down with your team, you've identified something that can that qualifies for IP protection, do not waste time. Go ahead and seek IP protection. URSB is open, and those gentlemen and ladies are very helpful. They really do offer a lot of help to any person that goes in to inquire. You will get a lot of help from there. And then the second mistake you need to avoid, please avoid disclosing your innovation too early. I've mentioned this countless times during our session today. Please make sure you do your due diligence prior to disclosing your innovation. And when you're disclosing your innovation, for those that get to have opportunities of pitching your ideas, please only stick to the business aspect of your innovation. Kindly stay away from the technicalities, because once you reveal this information, the technical information of your innovation, someone is taking notes. I know a number of us have been at exhibitions, have been at meetings, conferences, and you're busy talking about your innovation, and clearly you see someone taking notes. You clearly see someone taking pictures. Someone is recording your whole presentation. Before you know it, someone has redesigned what you created, and they've actually taken time to go and seek protection prior to you even doing it. So we need to be very careful with how we handle the disclosing of our innovations. And then also, let's not ignore other IP rights. That is why, for example, if you go ahead and design a technical solution, for example, if I go ahead and design a model that detects coccidiosis in poultry, I have to go and do a thorough search and validate that, irrespective of maybe a model being in existence that literally does the same thing, there should be something unique that I will actually hold on to validate that to show that my innovation is actually unique. So we need to keep this in mind all the time. When you're designing trademarks, try and do a thorough search. And that is why we pay the 25,000 shillings to RSB when we talk about trademark searching, because we want to ensure that you're not replicating someone's someone already, a trademark that is already protected somewhere. Okay, even when you're suggesting names, the unique names, the unique brand names for your product, please ensure that you do thorough search. You do not want to get into conflict, or you do not want to infringe on someone's IP, because then we shall get into the legal issues, and we all know how this is really, really tedious, okay, and expensive. And then, as entrepreneurs and inventors and investors, please let's not overlook employee and co-founder agreements. These documents are a very big stronghold. And remember, still, as we look at these agreements, there should be something to do with non-disclosure for us to protect the trade secrets, the confidential information that I talked about earlier. That shouldn't be forgotten. Please, all these documents, when you bring in employees, when you're creating partnerships with teams for you to come through with company X, or you're designing property Y, please ensure that any person, okay, that comes through to do any sort of work or offering any sort of support, they have done their due diligence in regard to signing appropriate documentation, and IP ownership has to be very clear. That means as an entrepreneur, you need to have what we call SOPs, or what we would call an IP policy that has to be thoroughly followed by every person that comes through as a co-founder, or as a partner, or as an employee. And even prior to them signing these documents, please ensure that you give as much information to them as possible. It is very unfair for you to let someone sign a document and they actually have not taken time to read. Give them time to read, answer their queries, and if they know they can do what you're talking about, please then go ahead and put this in writing. One of the sayings here in our office is, for as long as it's not documented, it's not done. So everything that is done, any interaction that is done between the co-founders, between the employees, between you, the entrepreneur, everything has to be properly documented. Once we get to dispute resolution, hearsay will not really help. You need to have this backed up by documents, okay? So now, when it gets to intellectual property, I know the query is, some of us may be asking, how do I get started with this whole IP thing? Take the baby steps, consult IP experts, okay? Consult IP experts. Please reach out to them, okay? Or reach out to us, because you need to avoid mistakes. And some of these mistakes may be really costly, especially when you infringe on an already existing intellectual property right, so an already protected IP. So it is important that you seek as much information as possible. Kindly utilize our local IP office. Okay, for those in Uganda, URSB is always open Monday to Friday, 8 to 5 p.m. And then also, let's not restrict our thinking. Let's not restrict our innovativeness to just Uganda alone. Let's try to think global, okay? Let's try and create products or services that will push outside Uganda. And that means you also have to exploit the different protection routes, that is either through the World Intellectual Property Office or the African Regional Intellectual Property Organization. And then as entrepreneurs and business owners, please let's learn and do a lot of research. I've told you WIPO, that is the World Intellectual Property Office, offers free online IP survey, IP classes, and some of these actually you even get to be awarded certificates. So please sign up to the academy and take time, educate yourself, get yourself as much information as possible, and do not ever fear to ask. For as long as you have a query, please reach out and you will be guided on how best to go in regard to your in regards to protecting your intellectual property. And with that, I come to the end of my presentation.
Yeah, for that very detailed presentation. I guess it has answered many of the questions that we have. And I like that you've explored the basics, broken it down, the different types. We've been hearing terms like copyright, trademark, design, patent. So we live here with a good understanding of what those different ones are. And the fact that you went into each of them in detail, I believe all of us as entrepreneurs, we now know, and we can begin to think which aspect of IP for our business that we can start to explore and go through the process, right? So thank you so much. And we will now go into the questions. We already have some on the chat. We have very little time left. So if you have any question, please share it in the chat. And perhaps Theo can share her email address or something in case someone wants to follow up after. But I'll read the questions. Someone asked, Solomon Seriko asked, under trade secrets, does the company or the business that then uses the secret recipe under protection get fined, or is it limited to the person who leaks? So is it the individual who leaks who pays the damages, or is it the company?
Ideally, like I was mentioning earlier, it is important that every person that gets access to this very delicate or private or trade secret has to do their due diligence in regards to signing a non-disclosure agreement or a confidentiality agreement. Now, you as a company owner or as a business owner, having this information leaked will definitely be harmful to your business. That is one. But then the person that leaked this information will have to follow or will be eligible to serious consequences, because for as long as there is a written document, that non-disclosure agreement, yeah, for as long as they did sign that non-disclosure agreement, oh my dear friend, they will have to pay a very hefty fine, or they will have to really be fined for breaching their contract or for breaching the non-disclosure agreement. So yes, but still, it would be very complicated if a non-disclosure agreement was not signed right from the word go. Then you as a business owner will actually be constrained. And the query is, where is the evidence that the person that had access to this information was actually not meant to leak it? Okay, so you as a business owner, as an entrepreneur, it is important that you have this at the back of your mind.
Okay, and as a business counselor, we always recommend for businesses to have contracts. You find many people are working in your businesses and they don't have any sort of signed document. And these are some of the key clauses to put in the contract and the addendums, which could include the non-disclosure agreements. All right, so Henry Chigund is asking, how do you patent a scent? As a label or a trademark?
Okay, I want to correct this. You can't patent a scent, okay? But you can register that particular scent as a trademark. Now, I told you one of the requirements for anything to be trademarked is it must be unique and it shouldn't be distinctive. And it is quite very difficult to trademark a scent, because getting that very unique and distinctive scent is quite very complicated. But I would advise you that in case you design a scent or in case you create a scent, you could probably instead exploit a trademark to represent or an industrial design to represent your scent, okay? And then the industrial design would represent the packaging of your scent. But please, we cannot patent a scent as stipulated in your question.
Okay, and then finally, since we've run out of time, how does a person protect different or diverse design creations beyond the 10-year period in line with photography or product design? But this,
Now,
I think, yeah.
yeah, now photography and product design. Photography, of course, this is a copyright. Will qualify for a copyright. And like I said earlier, copyright protection is valid for your whole lifetime and then 50 years after death. The product design, or I think you're talking about the physical appearance of the packaging of the product or the actual product itself, this will only be valid for 15 years. That's as per the IP guidelines we follow, our national IP guidelines we follow. And then still within the 15 years for the actual product design, it has to be, you have to do your due diligence in regard to paying your renewal fees every 5 consecutive years.
All right, so just to give you an example, as I mentioned before, I work with Jibo. So that bottle that you know that has a tap, it has a design patent. And the initial one is more like, it's more square. Then it wasn't working very well. It was getting dented. We decided it would work better if it's more round. So we have a version 2 of that bottle, which you must have seen on the market. And we had to go back and do another design patent on that same one. So we have 2 patents running for the different designs that we have to keep renewing. And there have been infringements, but yes, the patent has actually helped to protect that that innovation. The last one, I think we also have some messages of gratitude. Thank you for well-organized presentations. It's been very comprehensive. And then Kakaire Daniel says, thank you for the initiative on the issue of copyright. His Excellency, the President, Museveni, has granted copyright for another rap. Did it really meet all requirements? Oh, the phrase or the slogan, you want another rap. Did it really meet all requirements because it was not really original? Are there some other exemptions to it? Yes, the question of a slogan or a tagline. How does that work with patenting?
I really wouldn't want us to really use the word patenting, especially when we are talking about copyrights. Yes. To be honest, I didn't know about this another rap copyrighted, but even if it was, ideally, he then owns it for his entire life and then still 50 years after, you know, death. And then ideally also, I would also love to mention that for as long as URSB sat down, evaluated and said this qualifies for copyright protection, then you have no right to say it doesn't meet the rights, because the examiners did look at it and felt it does meet the requirements. So now at our end, we cannot say it did not meet the requirements. There must be a basis for them to say, yes, this can actually move to be copyrighted.
Okay. So what this means is that if you're a business and you have a slogan or a tagline, that this can also be considered for copywriting, correct?
No, a slogan is a component of branding. Okay, is a component of branding. I would love to use, let me use MTN. When you hear the word everywhere, the statement everywhere you go, you definitely relate it to MTN, meaning it is also an identifier that is married with the actual trademark. So it is a whole thing when we talk about branding.
Okay. What is the best strategy for commercialization of patents, commercializing patents?
The best strategy for commercializing patents is, one, you can either license someone to exploit your patent on your behalf and pay royalties as per the terms and conditions you would have agreed upon. And then 2 would either be, you can completely sell off your IP rights, that patent right. It is also okay for as long as you feel it may be quite tedious for you to actually exploit. So that those are the most common 2 avenues that you can exploit in regard to commercializing your patent. You can choose to license, or you can choose to sell your IP. And the third is you could create partnerships, okay? And these partnerships still have to follow the number of terms and conditions, and that involves the confidentiality agreements or the non-disclosure agreements, the terms and conditions under which the partnership is going to be implemented, etc., etc. So you can still exploit some of those for as long as it is relevant to you and your business.
All right. Thanks again, Theo, and thanks again, our audience, for staying with us until this time. Just to re-echo, key learnings: start early. At the very least, find out, is it, I'll use the word patentable, your idea, or not idea, whatever innovation that you have. And then explore the regional organizations. I'll give you an example. As Jibu, we went to a RIPO, registered Jibu, the Jibu trademark, registered our design patent. We didn't even know we'd go to some of these countries at the time, but it has helped along the way as the decisions have been made to expand into these regions. We had already done the work of protecting the design and registering the trademarks. So get to work, and you can go to these places that she has cited, the WIPO and RIPO. Get more information so that you can protect your innovations. Someone has their hand raised. Theo has shared her email address, theomartha@gmail.com. You can find it in the chat. Reach out if you have any questions or if you want to embark on this journey. Sure, she'll be very helpful. That's all the time that we had. As usual, the recording will be shared in the YouTube channel. If you haven't yet subscribed, please do, because there is so much content there. All the previous sessions have been shared there, and it is always good information to refresh yourself. Other than that, have a good rest of the day. I'm looking forward to seeing you again next week sometime. Have a good day. Bye-bye.